Hello everyone, this is Nazarat Fatima and you're watching LiveLaw. Yesterday on March 27, an important matter was up for being listed in the Supreme Court. The Supreme Court, while deciding to hear the petitions challenging the release of 11 convicts in the Bilkis Bano case, asked if uniform standards in murder cases have been followed while allowing the premature release. A bunch of petitions have been filed in the Supreme Court challenging the decision of the Gujarat government. The bench comprising Justices K.M. Joseph and B.V. Nagaratna issued notice in the petition. The bench asked the parties to give a broad outline of the arguments which they will be raising. In reply to the same, Advocate Shobha Gupta, appearing for the petitioner, highlighted the gravity of the crime and said that as per the provisions of CRPC, it is clear that the state where the trial is held is to decide the remission application, and the impact of the crime on the society is to be considered while granting such remission. Another counsel for one of the petitioners, Advocate Vrinda Grover, said, and I quote, "The presiding judge of the trial court said no remission should be granted. The CBI also said that remission should not be given. Substantive sentence is on 14 counts of murder and 3 counts of gang rape. Fine of total 34,000 rupees and in default 34 years. It is undisputed that fine is not paid, so default sentence will come that has not been served." It was also added that during parole, the convicts were also charged for molestation and somehow the authorities have completely ignored that aspect. She added that both the policies of the state of Gujarat and that of the union government bar remission under such circumstances. The counsel appearing for one of the convicts argued that in the first place, 5 petitions should be dismissed as they are activists and have no locus standi. Moreover, the counsel also said that as per judgments of the apex court, the policy of the government prevalent at the time of commission of offence must be considered, and therefore the Gujarat government was justified in considering the remission applications under the 1992 policy. He also said that in the year 2022, the Supreme Court had held Gujarat government to be the appropriate government for remission, and even the review petition against the remission was dismissed. And as such, under such conditions, the challenge would not sustain. In response to the argument of locus standi by the lawyer, Justice Joseph held that now the victim herself has filed a petition and her petition has also been made the main petition. In connection with jurisdiction, Justice Joseph asked if the court could confer power over an authority that lacks jurisdiction, and also mentioned Antule's case, which held that the court did not have the power to confer jurisdiction over an authority. He also mentioned that the jurisdiction has not been challenged. Rather, it's the decision of the government that has been questioned. Mr. Malhotra, the counsel for one of the convicts, also pointed out that the convicts have already served 15.5 years in prison and have served their sentence. He added that they have been released based on their good conduct in the prison. He said that the plea is emotional and not legal. The court responded to it, and Justice Joseph assured the counsel, "We are not going to be overwhelmed by emotions. We have to put in a balance." Senior Advocate Abhishek Manu Singhvi laid some emphasis over the opinion of the judge who had convicted the offenders. He said that the presiding officer of the trial court had opined that there should be no remission for the convicts and had also informed the bench about the convicts having threatened the victim after release. Senior Advocate Kapil Sibal explained with regard to the locus standi, and I quote, "The objection on the basis of public interest, this is not a criminal prosecution. We are against the remission granted without the application of mind, against the law. What are the contours of discretion? PIL will lie." He also added that the matter was shifted from Gujarat to Maharashtra because no faith could be placed in Gujarat police, and now the same police has granted remission. He said it is ironical. The Gujarat government has in its affidavit submitted that the remission was approved by the central government. It is evident from the affidavit that the CBI and the presiding judge of the trial court objected to the release of the convicts on the ground that the offence was grave and heinous. The matter has now been listed on April 18th. That's all for today. Thank you for watching. If you like our video, please like and share. Also subscribe to LiveLaw and don't forget to press the bell icon for notifications.